And she says it's cool. The indictment is fine, even if Halligan wasn't legally appointed as of September 25th, because she's now ratified it.
That dog won't hunt, Monsignor.
No. Good Lord. That makes no goddamn sense. I mean, look, it looks to me like Bondi knows that she screwed up by not doing the 3-hat dance, which I still am so puzzled. And now she's trying desperately to save these cases. Welcome to Law and Chaos, where the Sandwich Man is on trial in D.C., Pam Bondi is desperately trying to save the prosecutions of Jim Comey and Letitia James, and National Guard troops are still barred from deploying in Portland. We've got a lot to cover, so let's get after it. Hey guys, I'm LuLAC, and with me as always is Andrew Torres. Andrew, how are you?
Hey Liz, I'm doing well. How are you?
I am great. And hey, for all of our listeners out there in New Jersey, New York, Pennsylvania,
California,
New York, obviously New York. If you have not voted, please vote. It's exciting. We have so many good candidates on the ballot.
We do.
Okay, we have so much to talk about as happens pretty much every day. Okay, we're going to start with the Sixth Amendment and learn what a husher is. Then we will head to lovely Albany, New York to learn about a new campaign to house New York Attorney General Letitia James. We'll talk about the issue of fake U.S. attorneys, particularly one Lindsay Halligan. The government has responded to the motion to disqualify her, and oh boy, it's a doozy. And we'll discuss ongoing litigation in Oregon over the National Guard deployment, or non-deployment as it is. And for subscribers, Justin Baldoni is back to teach us some Civ Pro again with an assist from the New York Times.
I can't wait. But first, dun-dun, docket alerts.
Dun-dun-dun.
Can we start off with a blast from the rancid past in Judge Eileen Cannon in Florida, who has failed to turn in her homework and got dinged for it today by the 11th Circuit?
This I believe.
Yeah. So, as we all vividly recall, back in the summer of 2024, Judge Cannon discovered that special counsels were illegal and used that as a reason to kill the Trump stolen documents case. But she was not done protecting her patron after Trump won the election, and it was clear that that case was never coming back against him, against the president. She also ordered special counsel Jack Smith not to release the statutorily mandated report that he prepared on his work to Congress, on the theory that releasing that report could prejudice the cases against Trump's henchmen Walt Nauta and Carlos de Oliveira, since the Merrick Garland's Department of Justice had appealed her earlier crazy dismissal. The government, as you might imagine, abandoned that appeal approximately 5 minutes after Pam Bondi took over the reins at the Department of Justice, at which point a whole bunch of media outlets moved to unseal Jack Smith's report, since there was no longer any case that it could possibly prejudice. That argument has been fully briefed for a while. In fact, 180 days have passed since Judge Cannon took the matter under advisement.
Yeah, you will be shocked to hear that Pam Bondi takes the position that she and she alone has the authority to decide whether this report gets released, and Judge Cannon should just keep it under wraps.
If Congress wasn't completely supine in the era of Trump, it might have something to say about that, right? Anyway, the watchdog group American Oversight filed a petition for mandamus because Judge Cannon is not doing her job for the 11th Circuit to tell her to do her job. They wanted the appeals panel to dissolve Judge Cannon's order blocking the release of Smith's report. And the 11th Circuit agreed that Cannon was totally derelict, but said it was going to give her 60 more days to turn in her homework.
So what I'm hearing here is that in 60 days, Judge Cannon is going to adopt Bondi's argument, but she'll throw in some absolutely batshit legal reasoning that no one ever thought of, and we'll be talking about this case for another 5 years.
100%.
Okay. Well, there was a piece of good news Friday from Judge Collar-Catelli in D.C., who enjoined Donald Trump's executive order purporting to require proof of citizenship to vote. This was a lawsuit brought by the DNC, the League of Women Voters, and LULAC, that's a Latino civil rights group. There were a lot of plaintiffs here.
Right. So what this arises out of is in March, Donald Trump issued an executive order directing the federal government to modify the federal voter registration form to require documentary proof of citizenship rather than testimonial. This is illegal in about 15 different ways.
Right. So the Constitution says that the times, places, and manner upholding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. So there are two entities in the Constitution who can change the law around elections. That would be the states and Congress, not the president. Also, there's Supreme Court precedent saying that the state of Arizona was not allowed to require documentary proof of citizenship to register to vote in a federal election. So, no, you lose.
Right.
But in less good news, last Wednesday, we passed yet another mile marker on the road to authoritarianism when the DOJ indicted Illinois congressional candidate Kat Abughazaleh and 5 other people, most of them local politicians, for protesting at the ICE facility in Broadview, Illinois on September 26. Abughazaleh was part of a crowd which briefly blocked a car trying to enter the facility, for which she's been charged with conspiracy to obstruct a federal officer in the discharge of his duties and assaulting and intimidating a federal officer.
Yeah, don't take legal advice from a podcast or anything, but this indictment is utter bullshit. Basically, this guy was on his way into work and had to drive slow. That's it. Like, how do you as a prosecutor write this sentence and not immediately quit your job? Here's what it says. It was further part of the conspiracy that the co-conspirators, including the names Abughazaleh and the 5 other politicians, physically hindered and impeded Agent A and the government vehicle such that Agent A was forced to drive at an extremely slow rate of speed to avoid injuring any of the conspirators, and in doing so, slowly progressed towards the facility to discharge the duties of his office. That is the whole conspiracy. Abughazaleh and the defendants banged on the car. Don't bang on the hood of federal agents, right? But then somebody else, not one of the named defendants, scratched pig into the paint. Don't do that either. And then somebody else, again, not one of these named co-defendants, pulled off the driver's side mirror. And look, I am sure, I mean this sincerely, that it was scary to have people beating on your car windows and shouting. But charging this as a federal conspiracy to impede, and all, that's nonsense.
Yeah, I think it's important to understand just how much this indictment is a creation of right-wing media. Abughazaleh is only 26 years old, but she's been a thorn in the side of the right wing for years. She used to work for Media Matters for America, making fun of Tucker Carlson. She's been an independent social media influencer since the Media Matters was forced to downsize because they got sued by Musk. She's a fervent Palestinian activist. And then because the Democratic Party was so reluctant to embrace Palestinian causes, she decided she was going to challenge Jan Schakowsky. Schakowsky hadn't announced that she was retiring. I mean, look, in fairness, Schakowsky is like 80. I think she's 81. So Abughazaleh's point is that somebody young has to jump in, and she's definitely young. So she's been really visible at ICE protests. Right. Because, in part, she has this huge platform and she's very telegenic. And DHS has approvingly posted video of her being slammed to the ground.
And she is a tiny woman, like 5 feet tall.
Yeah, it's awful, but they love this shit. Laura Loomer and Laura Ingraham cheered, and a bunch of social media influencers in the conservative ecosystem demanded that Attorney General Bondi prosecute. And here we are. They've turned protest into a conspiracy. And I think it's really important to kind of flag this. It's important because they've targeted her because she's who she is. And it's also important because they want to criminalize protest. And the way that they're doing this here is they're saying it's a conspiracy and all of these people agreed. And so they're all jointly liable for every single thing that happened. And so Abughazaleh and the other co-defendants are liable for someone writing the word pig in the guy's, in the paint, scratching it into paint with a key or whatever, even if they didn't do it. And I don't think that they did. In fact, there's no allegation that they did. But that's what this is. This is an effort to criminalize protest.
Yeah, and that is not the law of conspiracy, right? We saw the DOJ try this out in Texas as well with respect to saying anybody who shares the Antifa ideology, that means you're all part of the Antifa conspiracy, and that means you're all jointly responsible. That's just not how it works. A conspiracy requires agreement, a meeting of the minds in furtherance of an objective, and that is not the case here. And I gotta say, I think this one could backfire on the right wing pretty heavily, right? Like the last poll before her arrest showed Abughazaleh in second place behind the mayor of Evanston, Illinois, in that Democratic primary. And whoever wins the primary is going to win the general election. She is now front page news, basically able to raise infinity money for her congressional campaign, and good for her. And the charges here are, the conspiracy charges are just so weird. Like, she stood in front of a car, and you want to make that a federal conspiracy? Like, be for real. Typically, the way in which these kinds of cases get prosecuted, if at all, is they're brought as obstruction, and under the federal sentencing guidelines, if you accept responsibility and you are a first-time offender, that brings the offense level down to Zone A, at which point the judge awards probation. Right? That's what should happen. This should not be a case that is going to trial, but who knows? And it is Tuesday. That is the day on which we thank our new subscribers who support the show. So a big thank you to everybody who signed up over at patreon.com/lawandchaospod. Gives us as little as $1 every episode. You get all the goodies. You get the extended episodes. You get everything ad-free, and you help keep us going. So a big thank you on Patreon to Patrick Knaus, Elizabeth Scola, Julie Beth of Tarth, Caleb Hoos, Hank, William and Kristen Lynch, and Nathan Detroit.
Good old reliable. And over on Substack at lawandchaospod.com, thank you to Ali Coquette, Scott Bindleclass, goodbye and hello, Scott, Bruce Diamond, Count Nefario, Amy K., Jeffrey Kusama Hinte, Sean C., DeSillis, Helen Keir, Robert Dreenan, and founding members David Remis and Scott. Thank you so much. Okay, we're going to take a quick ad break unless you are a subscriber, in which case no ad breaks for you. Not today, not ever. And we're back. Happy Sandwich Day to all who celebrate.
It actually is National Sandwich Day. That's one of my high holy days. Yeah, no, it really is.
Okay. It's also the first day of the trial in the case of Sean Dunn, the guy who threw a sub at a CBP guy in D.C.
Oh, the hoagie hero. Well, look, I can celebrate for two reasons. Mm-hmm. This trial is going to be interesting, right? Because this is one of those cases where the Department of Justice got no-billed with the grand jury when they tried to indict Dunn for felony assault with a sandwich, which is amazing since the incident was caught on tape, and it sure looks like it meets the statutory definition of assault. But U.S. Attorney Janine Jugwine Pirro couldn't bring it home. Grand juries don't even need to be unanimous, and yet she still could not get them to indict this guy who has since become somewhat of a folk hero, I am given to understand, in the District of Columbia. So the case got downgraded to a misdemeanor, which does not require you to go to a grand jury to get an indictment.
Mm-hmm. And the trial is off to a really weird start because Judge Carl Nichols opted to do the entirety of voir dire using hushers. Voir dire is when potential jury candidates are interviewed to, ensure that they don't have any bias. And hushers, actually, Andrew, you want to talk about that since you are a practitioner?
Sure. So courtrooms are presumptively open and everybody is mic'd up. So if other litigants or members of the press or the public are sitting in the gallery, they can hear your answers to questions. And other juror candidates can hear them too. But if a candidate gets asked a very sensitive question or one that they have an answer that they do not want the gallery to hear, judges have this little white noise switch at the bench. And so what the judge will do is call you up, flick the switch, that shuts off your mic, and what comes through the speakers in the courtroom is static, right? White noise. So if you need to say something to the judge that you would not like the entire courtroom to hear, the judge can use the husher to keep that largely confidential. But typically that is done on a case by case, on an item by item basis, right? Here, what Dunn's lawyers are saying is that Judge Nichols had the husher on the whole time so that nobody could hear anything.
Yeah, and there's also a reference in the motions to a phone contraption, which I assume is some sort of device to communicate without being overheard by the rest of the gallery. I've only seen this in state courts where they invite you up to the bench. If you say I can't be whatever, I have some sort of conflict, you come up to the bench, the judge flicks the white noise machine on and nobody in the room can hear you. But my understanding is that they used it for the whole thing and then they used some sort of phone contraption.
Yeah, your guess is as good as mine on the phone contraption. I haven't seen that before, but
maybe someone will write in and tell us.
Yeah, but I think I agree with your reading from context clues. Let's talk about the legal issue, right? Because the first clause of the Sixth Amendment to the Constitution says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury.
Yeah, so let's start with the public trial part. Courtrooms are presumptively open, right? That's a principle that goes back to the founding. We do not have secret trials. The public gets to watch and the press gets to report on it. But sometimes that presumption of access runs up against other things like confidential stuff or national security information. And in those cases, the Supreme Court set out a 4-part test for when you can close the courtroom to the public. That was in a 1984 case called Waller v. Georgia. So Dunn's argument is that using the husher for the entirety of voir dire is the equivalent of closing the courtroom without, doing the 4-part Waller test.
Right. And there are really 2 threshold legal questions to evaluating that argument. The first is whether the public trial right applies during jury selection. And that was definitively answered in the affirmative by the Supreme Court, but not until 2010 in a case called Presley versus Georgia. So you do have that Supreme Court decision said that the Sixth Amendment right to a public trial extends to the voir dire of prospective jurors, right? So the right inheres in the criminal defendant, not in the press to have a right of access. And the Supreme Court has said that does apply when you were talking about selecting the jury. But then there's a second question, and that is whether using the husher counts as closing the courtroom. And that is not clear-cut. Right. In fact, there is a contrary decision that is a state court opinion by the D.C. Court of Appeals. That's D.C.'s state Supreme Court from 2019 in a case called Blades versus United States. And in that opinion, the D.C. Court of Appeals said that using the husher through the entirety of voir dire, the exact same practice here, was not closing the courtroom, but was in fact an alternative to closure, which is one of those 4 Waller factors that you alluded to, Liz. Now, I should say, I do not agree with this decision, and a federal court does not have to follow a D.C. state court interpreting the U.S. Constitution. But here was the logic, right? The D.C. Court of Appeals said that if people in the gallery can still watch the proceedings, even though they can't hear anything, and then you can view the transcripts afterwards, that is what they called a reasonable alternative to the closure of the courtroom that enables the public to see the court proceedings, including facial expressions and body language of at least some of the participants at the bench, and thus honors the defendant's right to a public trial. And no, it doesn't, right? But I don't know how that argument would land with Judge Nichols and or on appeal to the D.C. Circuit.
Right. So sometime around lunch break, basically, the lawyers for the Sandwich Man filed a motion to kind of open this thing, and they said, this is terrible. And then at the conclusion of voir dire, they said, we think, Your Honor, that we should redo voir dire with a non-hushed grand jury selection process. Right. And Judge Nichols said no. From a practical standpoint, that train has now left the station. They have impaneled the jury. The cake is baked. So look, that means that Dunn's lawyers, if they don't like the victory, will be left to argue that Judge Nichols committed reversible error by using the husher. I don't know. I've spoken to a couple of criminal lawyers today who said that they thought that was probably reversible error. But who knows, right? You've got that other D.C. Superior Court case. But in any event, I suspect the case will be resolved by the time we next record the show on Thursday night. Even Judge Nichols was like, this is the simplest case in the world. Why do you need more than a day, basically?
Right.
Look, part of what's happened here is that Dunn, the sandwich man, has asserted his Sixth Amendment right to a speedy trial. He opted not to waive it. Most defendants do.
Yeah, we have seen criminal defendants in D.C., in New Jersey, and I imagine now in the Eastern District of Virginia, opt not to waive their speedy trial rights and to force the government to be prepared to go to trial within 70 days, which is what they're required to do under the Speedy Trial Act. I have interpreted that as a bet against this administration's competence, right? Particularly when you have legal luminaries like Jeanine Pirro, Alina Habba, and Lindsay Halligan leading major U.S. attorneys' offices. But Liz, I think you think this also interfaces with the jury nullification point. So you want to draw that out for us?
Yeah, look, I've been really a little reluctant to talk about this publicly because it's essentially a vote against it's a vote against civil society. It's a vote against the justice system as constituted to say that you hope for jury nullification or even that you expect it to occur. But I think
you want to define jury nullification so that we're just being clear?
Jury nullification is when the jury says, we don't really care about the evidence. We think the law is bullshit, or we think that the prosecutor is bullshit, or we really like the defendant and we refuse to convict. And there's jury nullification has often been used as a tool of racist repression, right? White jurors would often refuse to convict white defendants of crimes against Black people. Jury nullification is basically a big middle finger to the law. And if you believe in the law, you think jury nullification is wrong. I mean, it's actually illegal, but, from a moral standpoint, you think this is bad. I think what's happening in D.C. is that there is a really strong look. I mean, this guy's on camera throwing that sandwich at the CBP guy, and the grand jurors wouldn't indict him, right? They no-billed this case. There was another case we've talked about a bunch of times on this show, Sidney Reed. The grand jury no-billed that one 3 times, and then she was immediately found not guilty, acquitted. Now, that was a ridiculous case because that was the one where the ICE agents assaulted her. I think it was an FBI agent, assaulted her and then tried to indict her because bruised knuckles or something. Right. So the jury acquitted there. I think what's happening here is that Reed and now Dunn have opted to go to trial as fast as possible to take advantage of this window where their fellow DC citizens are super, super angry about their city being functionally occupied by all of these heavily armed men committing, constant civil rights abuses and harassing people on the streets. And so I think that that's kind of a bet on jury nullification. And I think it will be very difficult for the prosecutors here to get 12 city residents in D.C. to convict this guy.
Yeah, I hadn't thought about it that way until now, but certainly, right, people are very, very mad now. And if this case went forward a year from now, they would be less mad and perhaps less willing to do that. And I share those concerns with you. I don't know how to interact as a lawyer who loves the rule of law, watching an administration that wants to shred it. And, on the one hand, you have are you going to play by the Marquis of Queensberry rules? On the other hand, you have what are we fighting for here? So I'm glad we talked about it.
Okay. All right. We're going to take a quick ad break and we will be right back. Let's talk about a case which was unsealed in the Northern District of New York with the catchy title, In Re Grand Jury Subpoenas to the Office of the New York State Attorney General v. United States. The New York Attorney General is, of course, a person we talk about a lot in these parts, one Letitia James.
Tish James is the real racist.
Thank you, President Trump. No, for serious, he actually said that. He said Tish James is racist against white people because he, Donald Trump, our president, is demented. Okay, so we wrote about this case on the Substack. It's not paywall. Go check it out. But I want to talk about it here on a more meta level because it really sits at the intersection of a bunch of major legal issues that we talk about a lot on the show. Mm-hmm. Obviously, there's the weaponization of government against Trump enemies, but also you have this illegally installed U.S. attorney because only a lackey would do the shit that these U.S. attorneys that Trump sticks in there are doing, that career prosecutors with respect to the office will not do that. And of course, you have the trial courts pushing back against the lawlessness of the Supreme Court and the administration by constructing an edifice of rulings, pushing back on the administration's flagrant law breaking.
Yeah, it really is like the scene from Jurassic Park where the scientist marvels at the velociraptors learning to hunt in packs.
Yeah, clever girl.
And then they all got eaten.
Yeah, the analogy is almost too perfect. Okay, let us start with the case in itself, the In re grand jury case. On August 6th, John Sarcone, the acting U.S. attorney for the Northern District of New York,
allegedly,
he issued a grand jury subpoena on the Attorney General's office for basically every document in two cases. They are New York v. Trump and New York v. the NRA. Those are the civil fraud cases James's office successfully prosecuted against Trump's business and the National Rifle Association, both of which had very hinky books.
Yeah, and it is important to stress that these litigants, Donald Trump and the National Rifle Association, have had their due process to hell and back, right? Trump made half a dozen or more motions to dismiss the case for selective or vindictive prosecution and bias. He filed actions in New York State Court. He sued Tish James in federal court in Florida. He even filed an action in the Northern District of New York, and each and every time the judges said no. This case was appropriately predicated, and okay, the state intermediate appellate court knocked down the damage award substantially. That is on appeal to the New York State Supreme Court, but that intermediate appellate court decision did not disturb the verdict. It did not disturb the factual findings, and it upheld the predicate for the investigation.
Right. And similarly, the NRA tried to get its case dismissed on the theory that James was persecuting it because of bias, blah, blah, blah. And no dice. Court said no. Okay, so Sarcone signs these subpoenas in August, and immediately every news outlet in the country knows about them and knows about the investigation. You may infer from that one what you will. The New York Times cites sources saying that the plan here is to criminally prosecute James for violating Trump and the NRA's civil rights under 18 U.S.C. Section 242. That's a law which is supposed to protect prisoners from being treated worse on account of their race. So using it in this way would be pretty disgusting and vile. Yeah. The Attorney General moved to quash the subpoenas for being grossly overbroad and an intrusion upon state sovereignty, and because Sarcone was not legally appointed as U.S. attorney.
Oh, I think I hear my walk-up music, Liz. Okay. So we have talked about this issue with respect to the Lindsay Halligan indictments in the Eastern District of Virginia, and we talked about Alina Habba LARPing as a U.S. attorney in New Jersey, and we've talked about Bill Asaley and Sigal Chattah staying on past the expiration of their interim appointments in Los Angeles and Nevada, respectively. Every court to consider this issue has said that these appointments were illegal. But those rulings are also building on each other in really important ways, right? The velociraptor pack hunting that you talked about.
Yeah.
This, right? Because first, you had Alina Habba, one of Trump's personal lawyers who had never prosecuted a case in her life. She was appointed as interim U.S. attorney and served a 120-day term under 20 U.S.C. Section 546. The judges in New Jersey could have voted to retain her under subsection D, but they did not.
No, shocker.
Okay, right. So, Attorney General Pam Bondi did two things. First, she appointed Habba special counsel with all the powers of a U.S. attorney. And second, she made Habba the first assistant U.S. attorney on the theory that Habba could then succeed herself as acting U.S. attorney when she timed out of her interim appointment, and that succession would work automatically under a law called the Federal Vacancies Reform Act. It was not the first time that Bondi had executed this maneuver. She did the same thing a week earlier in New York with Sarcone, but it was the first case to make its way to court when criminal defendants challenged their prosecutions. because of the inherent tension between the judges of that district and the chief prosecutor, the case was assigned to a judge in Pennsylvania, Judge Matthew Brannon. He said, no, Haba was not validly appointed. He said the president gets one and only one 120-day interim appointment, and he can't evade the necessity for getting a permanent nominee confirmed by the U.S. Senate by putting someone new on the job every 120 days.
And that was, to be fair, the first time a court had ever ruled that way, although Sam Alito said it back in 1986 when he was working in the Reagan White House.
Indeed.
Inconvenient.
Yeah. Judge Brann also considered the Federal Vacancies Reform Act and the special attorney maneuvers, and he said that those wouldn't work either because one presumes that Congress means what it says when it passes a law, and allowing the president to simply zero out the requirements of Section 546 and the Constitutional Appointments Clause under Article 2 by just relying on the first assistant or special counsel which that would effectively void the statute, and courts don't do that.
But Judge Brann said that the cases should not be dismissed because other legally appointed U.S. attorneys were working on them. And that's more or less what the court said about Siegel Chada in Nevada. She's not the U.S. attorney, but the cases proceeded because other line attorneys worked on them.
Then we get to California, where Judge Michael Seabright was conscripted from Hawaii to consider the installation of Bill Abughazaleh as the U.S. Attorney for the Central District of California on the same playbook, right? Abughazaleh timed out as an interim appointee under Section 546, and then he got the same first assistant / special attorney titles. And Judge Seabright said, yes, I agree with everything those other judges in Nevada and New Jersey said. And also, the way I read the Federal Vacancies Reform Act, it only works when the U.S. attorney who resigns was actually Senate confirmed. If it's just some Trump lackey stuck in there as an interim appointee, that first assistant trick will not work at all.
Yeah. And just to be clear, I'm not sure we spelled this out. The first assistant trick is you put somebody in as first assistant and then they automatically ascend to become the acting U.S. attorney for 210 days or sometimes more when the principal resigns.
Right. And so what Judge Seabright said was, yeah, that provision of the Federal Vacancies Reform Act kicked in when the Senate confirmed U.S. attorneys who were appointed by President Biden resigned 10 months ago. They all do that. Like, that's what U.S. attorneys do when there's a change in administrations. The Senate has only confirmed like 16 U.S. attorneys, period, since Trump has assumed office. So under that reading of the statute, there are no U.S. attorneys who can bequeath their positions to the first assistant.
And that's where I really keep coming back to this. That's why I find this so interesting, right? We're watching these trial judges build an edifice against the Trump administration and its enablers on the Supreme Court, right? Each of these rulings is a brick that these trial judges are stacking up to wall in this like completely lawless administration. Because 6 months ago, it was not settled law that the president was barred from making successive interim appointments to this U.S. attorney spot. But Trump is like I said, he's hell-bent on getting his lackeys in these spots because no ethical, experienced prosecutor will indict his enemies. And that's what he wants, right? He's made that very clear. So what you're seeing is these trial judges pushing back. And now you have decisions in the Ninth Circuit and the Third Circuit, the Halligan case is in the Fourth, and Sarconi is in the Second.
And I think it's pretty likely to be a clean sweep. Yeah, at least at the trial court level. You never know what kind of panel you will get on appeal to the circuit court. But these decisions, as you point out, Liz, reinforce each other. The trial courts are pushing back hard at this gross corruption of the legal system.
Right. So, okay, we have the Halligan disqualification motion in the Eastern District of Virginia, which has been assigned to a judge from South Carolina. Let's put a pin in that for a hot second because the government, as we said, submitted its response to that motion to disqualify her today, and it is bonkers. But before that, let's circle back to Sarconi because he's the only one who signed those subpoenas on the New York Attorney General's office for the Trump and NRA case documents, and he signed them in his position as acting U.S. attorney for the Northern District of New York. So the question here is whether the judge, who, by the way, has been seconded from the Southern District of New York, she's a senior judge. So the question here is whether that judge will say Sarconi is disqualified, but the subpoenas survive, or whether she will say, you're out of here and those subpoenas are a nullity.
Yeah, and On that issue, I think it is probably the former, if I had to guess, right? Because this is different than Halligan being the only person to take an investigation and procure an indictment, right? Like issuing a subpoena is a much more ministerial act from the office. And Sarconi has some valid powers under 28 USC section 515. That's the special counsel statute, right? Like the attorney general can hire outside lawyers to be helpers. We don't know what they are. We don't know how far they extend because of how that would potentially interact with the exclusivity provisions of the Federal Vacancies Reform Act. There are a lot of legal balls in the air in terms of Trump trying to do a full end run around the statutes. But where I come down is Sarconi definitely could have been delegated the power to issue subpoenas. And I would also imagine that there is probably some evidence that other folks in that office assisted on issuing the subpoenas, even though their names aren't on it. So I don't think this is going to knock out the subpoenas. But I'm also I don't think this is the best argument that James has to quash those subpoenas.
Right, but she does have others.
Yes.
Right. I mean, she's got all of those. This is, completely inappropriate. All right. Obviously, we're having this discussion because the New York Attorney General won its motion to unseal this case. It was because it referred to grand jury materials. It was first filed under seal, and the government said no, that would compromise grand jury secrecy. I think I would infer from that they would prefer to do their campaign of harassment behind a paywall. But anyway, we've now seen a lot of the documents in this case. And Judge Lorna Schofield from the Southern District of New York said that while grand jury materials are secret, this investigation isn't a secret since every media outlet in the country already covered it. So now we're going to get to watch this dispute over the grand jury subpoena unfold in public. And we'll see whether the Trump administration is going to get to interfere with state law enforcement. And relevant to my personal peccadillos, we will get to see Sarconi get disqualified, which is another brick in that edifice.
Yeah. Before we leave this story, can I just play out that last bit for a second? Because I want to make it clear what Sarconi is looking for by issuing those subpoenas. What we have seen Republicans do over and over again is weaponize internal dissent among law enforcement agents, right? Like in the search at Mar-a-Lago, there was one guy at the FBI field office who said, he would have rather done a consensual search than execute a search warrant. And that guy, Steve D'Antuono, is now Exhibit A in their claim that the raid was illegal, despite the fact that D'Antuono himself testified that the search warrant was totally legal, just that he would have done it differently. But it wasn't his call. He was not the decision maker. And D'Antuono's internal communications and that good faith dissent, what we want to see among law enforcement officers, right? Like we want to see debates going back and forth. That's the basis of Donald Trump awarding himself $230 million in reparations or whatever he's calling it. And that's what they're looking for here. They want a piece of paper from somebody somewhere that says, hey, are we sure we want to go forward? Are you sure we would charge somebody under these facts if it wasn't Trump? Or it seems like the predicate here is a little shaky, or something else in context or out of context that they can use to say that those cases were not appropriately predicated, despite multiple courts having already determined that they were. That is the point of this exercise. That and to discredit the New York Attorney General.
And harass her. Yeah. Agree totally. Okay, let's take a quick ad break and we will be right back. And we're back. Okay, let's return to that issue of Lindsay Halligan, the wannabe chief prosecutor in the Eastern District of Virginia. The government filed its response today to the motion to disqualify her. And actually, that response was doing double duty. Tish James, who is, as you know, indicted in the Eastern District of Virginia by Halligan, and James Comey, they filed separate motions to disqualify her, but the response was consolidated into one motion. And the same judge who has been seconded from the District of South Carolina, Judge Cameron Curry, is going to consider both of those cases next week. Okay.
Right.
The government's response is, I think the technical term is fuck bonkers.
Yeah. So in the last segment, we talked about Alina Habba, Abughazaleh, Sigal Chattah, John Sarconi, all wearing 3 hats from 3 separate laws. What makes Halligan unique is that Pam Bondi did not run that same playbook as she did with those other interim/special/whatever. She just stuck Halligan in the job as an interim U.S. attorney under 28 U.S.C. Section 546 on September 22nd and then called it a day.
Right, which is weird because she'd been doing this, the 3 hats dance, basically, since July. She'd done it with Abughazaleh, Chattah, and Habba. And with Halligan, she was like, it's fine. And that was after the court in New Jersey had said, no, that will not work. You get one 120-day appointment, and that is it. I'm not sure what happened here.
I don't either, because there's no dispute that Donald Trump had already used up that 120-day appointment on Eric Seibert, right? The competent prosecutor that he pushed out because Seibert refused to indict Comey and James, right? And what that means is if the administration loses on 546, those indictments are, we think just DOA.
Yeah. So the prosecutors here had to defend it, which is a pretty tall order, especially because they're not super senior guys. Halligan brought these guys in from North Carolina because no one at EDVA will touch these dog shit prosecutions. And Judge Curry has already asked to see the grand jury transcripts to determine the extent to which the, quote, indictment signer was involved in securing the indictments. So, as somewhat inauspicious. She as you said back in the Sarconi segment, Halligan is the one who presented the entire case to the grand jury. She's the only one that signed the indictment. So the name of the game here for the government is to say, actually, it's fine. Don't dismiss these cases. So first, they argue that Halligan was too validly appointment. And second, they say, even if she wasn't, the remedy is not dismissal. So the DOJ starts off with this maximalist argument. They say, all right, you say we aren't entitled to put in a new interim U.S. attorney every 120 days. Actually, no, the law will let us put in the same person and just keep renominating her over and over and over forever. We never have to go to the Senate to get someone confirmed. It's fine, see, because... I literally, this is what they say. If the attorney general thinks about it, reconsiders it every 120 days, that makes it into a new nomination. And so she just keeps getting to do it.
There is about 10 pages of that in this opposition that are just jaw-dropping, right? And I should say the Trump administration seems to have invented this argument just about yesterday, because if they had ever thought at any time in the past that that was really what the law said, then they wouldn't have had to do that 3-hat dance with Habba or Abughazaleh or any of the other folks, right? Like they could have just said, nope, they're going to serve another successive interim term, but they didn't because they knew they couldn't, right? We all remember Pam Bondi saying, oh, I sure hope the judges reappoint Alina Habba. No, they didn't because they're political, so we're going to have to do something else.
Right, and let's play this out here. The reality of their position is, yes, the law says that we have to get Senate confirmation for these people, but actually we don't. We can just keep thinking about it every 120 days and renominate the same person 11 times in a row. That, first of all, that would zero out all of the laws, which is, as we said, that's not what courts do. And second of all, it would be in total defiance of the Constitution's appointments clause, which says you only get to, appoint principal officers with advice and consent in the Senate.
Yeah. And as bad as that argument is not the amazing part in this opposition. Liz, I have to read the amazing part to you. This is Exhibit A, a declaration signed by one Pamela Jo Bondi on October 31st. And that date is going to be significant. She writes, on September 22nd, 2025, I exercised the authority vested in the Attorney General by 28 U.S.C. Section 546 to designate and appoint Lindsay Halligan as the U.S. Attorney for the Eastern District of Virginia. For the avoidance of doubt as to the validity of that appointment, and by virtue of the authority vested in the Attorney General by law, including the special counsel statutes, I hereby appoint Ms. Halligan to the additional position of Special Attorney as of September 22nd, 2025.
What?
Yeah, to time travel, and thereby ratify her employment as attorney of the Department of Justice from that date going forward. As special attorney, Ms. Halligan has the authority to conduct, in the Eastern District of Virginia, any kind of legal proceedings, civil or criminal, including grand jury proceedings and proceedings before U.S. magistrates and judges. In the alternative, should a court conclude that Ms. Halligan's authority as a special attorney is limited to particular matters, I hereby delegate to Ms. Halligan authority as special attorney to conduct and supervise the prosecutions in U.S. v. Comey and U.S. v. James. Those prosecutions existing only because Lindsay Halligan brought them in. So anyway, back to Bondi's affidavit. In addition, based on my review of the grand jury proceedings in U.S. v. Comey and U.S. v. James, I hereby exercise the authority vested in the Attorney General by law to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments returned by the grand jury in each case.
Aha. So Pam Bondi signed a document Friday which purports to appoint Halligan as special counsel and backdates that appointment to September 22nd, 6 weeks ago. And she says it's cool, the indictment is fine, even if Halligan wasn't legally appointed as of September 25th, because she's now ratified it.
That dog won't hunt, Monsignor.
No. Good Lord, that makes no goddamn sense. I mean, look, it looks to me like Bondi knows that she screwed up by not doing the three-hat dance, which I still am so puzzled. And now she's trying desperately to save these cases.
I think that is exactly right. And I should say the government's arguments here just badly misconstrue the law. The main argument is this argument about de facto officers. And let me just unpack that for a second, right? A de facto officer is when everybody around agrees that they thought this person was validly appointed, but then it turns out that there is some technical defect. And the citation that they give here, that there's not a citation for U.S. attorneys, it's to a 1976 case called Buckley versus Vallejo, which had to do with campaign finance reform. And it was talking about the members of the commission. And the Supreme Court said that in the same way that we don't undo legislation voted for by members of Congress who turned out to later have been improperly redistricted, like we're not going to go back and undo actions by apparently de facto officers, by people everybody thought was validly on the job. But nobody thinks Halligan was validly on the job.
Yeah, I have a couple of thoughts. And the first is that this is kind of the inverse of all of these firing arguments that Trump has been able to get through to the courts, right? That he's convinced the Supreme Court to basically, on the shadow docket, let him fire every single federal official, aside from Lisa Cook on the Federal Reserve. But he's convinced the Supreme Court that he can fire at will anybody, despite the statutory language saying that they can't be fired for political reasons. Fine. That is the world that we now live in. But that's not enough for him. What he wants is the right to actually appoint people without the advice and consent of the Senate, right? That's kind of many steps further than the Supreme Court has thus far been willing to go, right? He's fired all of these members of the multi-member board. He's gotten the Supreme Court to overturn Humphrey's executor and Saylor Law, those cases we've talked about so many times. Right. But he has said, and in fact argued in court, that he has the right to appoint, basically replace the entire board of, say, the U.S. Institute for Peace or whatever with lackeys, Marco Rubio, whatever. And that's not a position which the court has yet endorsed.
Yeah, they haven't rejected it either. But
Right. But that's what he's saying here. And the argument in this response, the government leans really hard into that. And they say, well, if you don't let us put these, staff the executive branch with people that we want, it's gonna, it's hampering the president's inherent authority. And yeah, that's pretty offensive.
It is. I think it's also, again, I hope pushing the Supreme Court too far, although that hope has not been well-founded in the past 9 months. But look, there's a difference between the argument that, again, I don't think it's a good one, but that one favor at the Supreme Court that said, don't saddle me with Biden appointees, right?
Yeah.
Let me fire them and get them out. But that's very different than saying the Constitution provides for separation of powers of how officers of the United States are meant to be appointed, but you should ignore that anyway in favor of this grand unitary executive theory that Russ Vought cooked up. I hope it's a bridge too far. I don't know.
Yeah, I think it will be. My other thought is with respect to Sarkozy, right? That like, as you said, Sarkozy had all of these other grants of authority, right? That Sarkozy they did the 3 hat dance with him and probably somebody else from he was the only person who signed the grand jury's subpoenas. But he at least had this kind of authority, which Pam Bondi is trying to, project backwards in time 6 weeks and say that Lindsay Halligan had when she, very clearly didn't have it. And that makes me think that these indictments, the Tish James indictment and the Comey indictment, are not long for this world because Bondi didn't give her these alternate grants of authority, at least not in real time, and because she was the only one who secured the indictments.
Yeah, and we have much more on that in the DOJ's other opposition that got filed today, and that's just going to have to wait for Friday's show.
Yeah. Okay, let's take our last ad break, unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, nope. Last week, multiple media outlets reported that Trump is dissatisfied with ICE because they're not brutal enough. I know that sounds like a joke, but it's actually not. Trump likes Customs and Border Patrol because they go out and beat the shit out of people and they don't complain about it. And so lots of high-ranking ICE officials were fired last week and replaced with goons from CBP.
Yeah, guys more in the mold of Greg Bovino, the sociopath leading the invasion of Chicago. He's like the bastard child of Colonel Jessup from A Few Good Men and Colonel Kurtz from Apocalypse Now.
Yeah, the pictures of him like doing Nazi cosplay were amazing. Anyway, ICE was theoretically in cities to grab up bodies to deport. CBP is pretty clearly there to intimidate the locals. That's why Bobino keeps posting images of himself like on the prow of a boat on the Chicago River in full battle rattle. That's about domination. And in some sense, it's about provoking a backlash and then using that reaction to retcon a legal justification to flood the streets with soldiers, or in this case, to federalize the state's National Guard. We've talked a lot about litigation by the states seeking to block that federalization and deployment of National Guard troops in their streets. The Supreme Court is still mulling the Seventh Circuit's ban on deploying the Illinois National Guard to Chicago. But meanwhile, in Portland, we got our first actual trial on the merits of Trump's emergency federalization and deployment orders.
Yeah, this story is as much about civil procedure as it is the underlying legal issues, because normally there are 2 sort of tracks for civil litigation where you're seeking injunctive relief. There's the emergency track where you get temporary injunctive relief, and then the merits track where you get your permanent relief, right? So initially, the Oregon plaintiffs approached this litigation, for lack of a better word, normally, right? Like they asked for a temporary restraining order to block the government from sending in the troops as soon as Trump's federalization orders came down. They got it. They got 2 of them, actually. And now temporary restraining orders are supposed to last for 2 to 4 weeks and preserve the status quo. And typically, as plaintiffs, what you do in those 2 to 4 weeks is you conduct expedited discovery. You tee up a motion for preliminary injunction, right? That is still on the temporary track. But if you win on the preliminary injunction, that PI can run through to the end of trial. And you go through the full discovery process on the merits. You go to trial, you put on your witnesses, and finally, the court can issue a decision on the merits of your contention. If you win, you get a permanent injunction. But that's not what's happening in any of these cases involving the Trump administration.
Right. The whole thing is warped because appeals courts and the Supreme Court have decided that TROs are immediately appealable if you're the Republican president. Right. And so these cases are all getting split. They're being heard simultaneously in the appeals court to litigate the validity of the emergency TRO. And they're still going on in the trial court on the merits. So here, Judge Karen Immergut, the trial court judge, issued 2 TROs in one weekend. First, Secretary Hegseth tried to federalize the Oregon National Guard. And then when she blocked that, he said, oh, that's fine. We'll just send in the California National Guard. And she came back and she blocked that one too.
Right. And the government appealed that first TRO immediately. And that issue is actually still pending at the Ninth Circuit since it drew a super Trumpy panel that sided with the government. And then the wider court said that they wanted a crack at it en banc. But meanwhile, the case on the merits was moving along at the district court level. And so in a normal universe where you can't appeal a TRO, Judge Immergut would be holding a preliminary injunction hearing right about now. But she said, I don't see why we should bother with that, right? Like, let's just skip over that preliminary injunction hearing. And, it's not like you guys need lengthy discovery. Let's just go straight to trial. So she put this on a rocket docket for a trial date 28 days later. So that takes us to last week from Wednesday to Friday, where Judge Immergut held a 3-day bench trial on the merits of whether the president properly invoked 10 U.S.C. 12406 to federalize the National Guard. But remember, temporary restraining order, they're temporary. So Judge Immergut's second TRO, the one that Trump didn't even bother to appeal, that was entered on October 5th, extended once. It was set to expire Monday, November 3rd. So absent some other intervention, Trump would have been free to just send in the troops today when that TRO expired.
Yeah, just to be clear, Judge Immergut is deciding whether it's legal to send in troops. And it's very clear that her answer to that is going to be hell no. She's the one that granted those TROs, right? So after that 3-day trial, Judge Immergut went back to the parties on Friday night and she said, look, it's Halloween. You're going to file trial briefs over the weekend and my TRO is going to expire on Monday. Can we just agree to maintain the status quo for another week so that I can rule on the merits expeditiously? And the Trump administration said no.
Which left you and me, and more importantly, Judge Immergut, let's say flabbergasted, right? Because the way that she rocket docketed this case to trial procedurally was through Rule 65A2 of the Federal Rules of Civil Procedure, which allows the trial judge to advance the trial on the merits and consolidate it with the preliminary injunction hearing. And because of that, Rule 65 meant that Judge Immergut retained the power to issue a preliminary injunction on Sunday while she spends the rest of this week writing a bulletproof permanent injunction that can hopefully survive the Ninth Circuit and the Supreme Court. And for reasons that are still not clear to me, I've read it several times, the Department of Justice took the position that the expiration of that temporary restraining order meant that they could send troops in immediately and there was nothing Judge Immergut could do about it.
I mean, we know the reason, right? You know why they did it. They're going to lose. They're well aware of that. And they want the status quo when they go to appeal this to be troops on the ground instead of troops not on the ground, right? I mean, they knew they didn't have a leg to stand on legally, but they had to try. So Judge Immergut issued this 6-day preliminary injunction on Sunday night, prohibiting the administration from implementing any of the federalization memos or sending any state's National Guard troops to Oregon. She also promised to rule on the merits of this case by Friday, November 7th, no later than 5 p.m.
Yeah, because Judge Immergut knows that we record this show on Thursday.
No, I mean, I know what you're saying, but I do want to draw a contrast between how hard these trial judges are working and how much they're trying to get this right. And the contrast between that and the Department of Justice coming in all of these cases with like absolute bullshit, right? Just two big middle fingers.
Yeah, and in any event, I think you and I can pretty safely pre-write that part of the script. Like when a judge issues a preliminary injunction saying, I think you're likely to succeed on the merits, 6 days before she gets to decide whether you've succeeded on the merits. Like you don't have to be a precog to figure out what's going to happen next, right? Judge Immergut is going to say that the government failed to meet the preconditions of 10 U.S.C. section 12406. Specifically, she's going to say there wasn't a rebellion and that the Trump administration was indeed able to enforce the laws without calling in the troops. And I should point out she's doing this while the law itself is in flux, right? Like that's what the Ninth Circuit en banc and the Supreme Court are going to work out, right? Like, are those factual determinations reviewable? How much deference is owed to the president's determination? So what Judge Immergut has done to try and bulletproof her opinion is assume that great deference standard that the Ninth Circuit laid out in the first Newsom v. Trump case, right? And so she said, look, like, yeah, okay, fine. Let the administration look back to June and say that protests in June justified sending in the troops in September, October, November, right? She says, give them every benefit of the doubt, and they still haven't met their burden. And I should say, the reason to do this, I've used the phrase bulletproofing in this segment a couple of times. Like when we as practitioners talk about a trial judge bulletproofing an opinion, what we mean is that they are making sure that it can survive a potentially hostile panel on appeal. And we know that there's a hostile panel waiting in the wings, right? With 2 Trumpers on it that is going to hear this appeal. They're the one that stayed her TRO last time. So one of the primary tools that judges have is to make detailed factual findings, because factual findings are reviewed by an appellate court only if they are clearly erroneous, while at the same time minimizing the reliance on legal determinations that the appellate court gets to look at de novo.
Yeah. Okay. So here's how the rubber meets the road on that one, because the Trump administration's primary argument, right, that remember there are 3 ways that you can federalize the National Guard: invasion, rebellion, or the president being unable with the regular forces to enforce the laws. That's the language of the statute. And that's mostly what Trump has said, basically, that he can't carry out the immigration laws, which is ridiculous. Like they've been deporting people right and left. They've been snatching people off the streets. The fact that there's protest hasn't stopped that. So here's Judge Immergut's factual findings, which she's front end loading this, as you said, because she knows that there's going to be a hostile appellate panel. She says the court finds no credible evidence that during the approximately 2 months before the president's federalization order, protests grew out of control or involved more than isolated and sporadic instances of violent conduct that resulted in no serious injuries to federal personnel. The violence that did occur during this time period predominantly involved violence between protesters and counter-protesters, not violence against federal officers or the ICE facility. Although card readers at the ICE facility were occasionally damaged, this court has found no evidence so far, based on the testimony at trial, that any significant damage to the ICE facility occurred in the 2 months preceding September 28th, 2025. The credible testimony has not shown that ICE was unable to effect arrests or otherwise perform the agency's duties, although the evidence so far showed that protesters frequently blocked the driveway of the ICE building. The evidence also showed that federal law enforcement officers were able to clear the driveway, and even when the building closed from mid-June to early July due to property damage that occurred on June 12th, ICE's Enforcement and Removal Operations Office was able to temporarily relocate to another facility in Portland for administrative purposes until the building reopened. So TLDR, the government's argument is we're not able to do immigration enforcement because because of graffiti or because people are blocking the driveway. And the DOJ has tried really hard to kind of blur the lines there and say, well, if there's somebody standing in the driveway and we have to move them, then we can't do immigration enforcement. And that's just clearly not the case.
Yeah. And I should add that she did the same thing with the same level of detail with respect to the government's fallback argument, right? So in addition to saying they've been unable with the regular forces to execute the laws, they've also been arguing that protest equals rebellion. And, they have this, it's the Shays Rebellion, it's the Whiskey Rebellion of 1794, and that just means people have to disagree on one discrete legal issue. And Judge Immergut basically said, fine. Even taking the maximalist view of what constitutes a rebellion, the government has put on no credible evidence that there was a rebellion. These folks did not have shared ideology. They weren't trying to overthrow an instrumentality of government, right? That they were just protesting. So, look, bottom line, I don't know if any judge anywhere can bulletproof this panel or the Roberts Supreme Court. But I know that Judge Immergut tried, right? It is a lie that Portland is some lawless hellhole in rebellion and under siege. And the question is going to be, in my mind, whether the courts are going to sit back and pretend as though that's a real argument or whether they're going to draw a line in the sand. But Judge Immergut has drawn it.
Okay. That is going to do it for us today, unless you are a subscriber, in which case we are going to hang out with Justin Baldoni and Blake Lively and learn some civil procedure. I will be sad once this case is resolved because it is a never-ending, source of low-stakes humor and also, civ pro lessons for us. But, okay.
I mean, Drake is going to the Second Circuit, so
for God's
maybe
sake,
we'll
that
have a
case is no fun at all. That case was just ridiculous. Baldoni, Lively for life, or at least for another 5 months. Okay, that's going to do it for us, unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case we got a little more for you. Otherwise, we will be back here on Thursday with written content and on Friday with another podcast. We'll tell you how that Sandwich Man lawsuit works out. See you guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.